Compulsory group insurance. The employer shall have the entire permanent workmen employed by him insured against risk of natural death, disability, and death or injury due to contingencies not covered by other laws. The employer shall be responsible for the payment of premium and other arrangements. If the employer fails to arrange for insurance, he shall be liable to pay the compensation of the heirs of the workmen like an insurance company. Payment of bonus. Every employer making profit in any year shall pay for that year within 3 months of the closing of that year to the workmen who have been in his employment in that year for a continuous period of not less than 90 days. A bonus in addition to their wages payable to such workers. Stoppage of work. The employer has the right to stop the working for some period of any section or sections without notice due to causes beyond his control. In case of stoppage of work, the workmen affected shall be informed. They will also be informed when the work will be resumed and whether they are to remain or leave their place of work. The workmen shall not be required to remain for more than 2 hours after the commencement of stoppage. If the period of detention does not exceed 1 hour, the workman so detained shall not be paid for the period of detention. If the period of detention exceeds 1 hour, the detained workmen shall be entitled to receive wages for the whole of the time during which they are detained as a result of stoppage. Layoff. The employer can lay off the workers on account of reasons mentioned in the standing orders. Such laid off workers shall be paid wages according to the rules. Closure of establishment. The employer is not allowed to terminate the employment of more than 50% of the workmen or to close down the whole establishment without permission of the Labor Code except under some special circumstances. Termination of employment. The employment of a permanent workman other than misconduct is terminated by giving 1 month's notice, either by the workman or by the employer, and in lieu of such a notice, 1 month's wages being average wages of the last 3 months shall be payable. The employment of a temporary workman, probationer, or badly may be terminated either by the workman or by the employer, without giving any notice or any wages in lieu thereof. The services of a workman shall not be terminated except by any order in writing which shall state the reasons for the action taken. The services of workmen shall not be terminated except by any order in writing and which shall also state the reasons for the action taken. When the services of a workman are terminated, the wages earned by them and the other dues shall be paid before the expiry of second working day from the day on which their services are terminated. Procedure of retirement. When any workman is to be retrenched and he belongs to a particular category of workmen, the employer shall retrench the workman who is the last person employed in the category. Reemployment of the retrenched workman. In case of a reemployment within 1 year, the employer can offer reemployment to the retrenched worker according to the seniority. Construction workers. Where any workman is retrenched or discharged, engaged in construction industry due to completion, cessation, or discontinuation of work, he shall be given preference for employment within 1 year. If such a worker is re-employed within 1 month, he shall be deemed to have been in continuous service, but no wages shall be paid to him for this period of interruption. Punishments. A worker shall be punished or fined according to the law. Eviction from residential accommodation. When a workman retires or resigns or is retrenched, discharged, or dismissed, or whose services have been terminated, he shall vacate the residential accommodation provided by his employer within a period of 2 months. If a workman whose services have been terminated fails to vacate any residential premises within the specified period, the employer may lodge a complaint with a concerned magistrate